I just can't seem to get it to work right. That's okay. Okay. Come on, man. Very good. You're muted. You are muted. Do you know how to unmute yourself? For some reason, I can't unmute you. So if you go up to the top of your right-hand corner of your video of you, there should be a place up there to click unmute. If you put your mouse up over that right-hand corner, upper right-hand corner. I'm going to give it a couple more minutes and then we'll get started. Okay, let's get started. Is there a particular form you want to go over today? If not, I'm going to start with a purchase agreement. Okay, what we hit. There we go. Good morning, Valerie. Valerie is connecting to audio. Buffy, I can't hear anything you're saying. You're on mute, apparently. So if you have anything that you need to say, you need to unmute yourself. And I'm going to go ahead and get started. So we'll start this morning with the purchase agreement. It honestly is pretty self-explanatory, but there are some things that you need to pay particular attention to when you're writing a purchase agreement. So we'll start at the top. Pretty simple. The listing broker, so whatever company has the listing, that brokerage is what goes here, their office number here, the agent's name here, the listing agent. By the way, if you have two agents on the listing, you have two co-agents, I generally go with the first one listed on the detail sheet in the MLS, and then their siren number. Then we would be the selling broker if you represent the buyer. So there would be Keller Williams Realty Consultants there. Our office number is 570. That's what goes here. Then your name and your siren number. My siren number is B1990. Yours might be just numbers, but it's whatever your ID is in siren. Hold on just a minute, guys. Okay, here we go. Then of course the date that you're writing the offer goes in the date section. The buyer's name, so this is one of the things you want to pay particular attention to. You want to get the buyer's legal given name, because the purchase agreement is what the title company is going to use to put on the deed. The lender is going to want that information, their complete information, because they want their complete name on the deed. So first name, middle name, and last name, junior, senior, the third, whatever it might be, but it really needs to be here. And if there are two buyers on the purchase agreement, both their names need to be here. If you have a circumstance where you have a couple, but only one of them is going to get the mortgage, then only their name would go there. Then next on line 7, it's the property known as, which of course is the property street address, followed by the township, the county that it's in, the city that it's in, and then the zip code. And then the next, one of the most important things on a purchase agreement is the legal description, because again, that's what the title company is going to use to deed this property. So if you have the wrong legal description, somebody might be buying the wrong piece of property. So legal description is very, very important. It should be on the detail sheet on the listing, but you can also go online and verify it through several different sources. Then the next thing down is together with any existing permanent improvements and fixtures attached, unless leased or excluded, including but not limited to, and it goes through a whole litany of things. Electrical and or gas fixtures, heating and central air conditioning equipment, and all attachments thereto, built-in kitchen equipment. So that would be the dishwasher, if it's a built-in microwave, by the way, a stove, a range oven, if it's just a simple drop-in, that could be removed very easily. You might want to make sure that you list that on the purchase agreement as items that would stay. Refrigerators are not permanently attached kitchen appliances, so they need to be mentioned too. And we'll get to that in just a minute. So gas fixtures, heating, central air, all attachments, built-in kitchen equipment, sump pumps, water softeners, water purifiers, fireplace inserts, gas logs and grates, central vacuum equipment, window shades and blinds, and curtain rods, and drapery poles. So this is something that is a point of contention a lot of times in a purchase agreement. So if you represent a seller, they need to understand that the purchase agreement says they're going to leave all that stuff unless it's called out in the purchase agreement that they're going to take it with them. Ceiling fans, light fixtures, towel racks and bars, storm doors, windows, awnings, TV antennas, wall mounts. So wall mounts are to stay unless they're called out in the purchase agreement as something that will not stay. Satellite dishes, the same thing. Storage barns, all landscaping, mailboxes, garage door openers, with controls, and then the following, and if applicable, smart devices in homes. So smart devices have become kind of a big thing. So what is a smart device? It could be a thermostat that's called a smart thermostat that you maybe can control with your phone. It could be security systems, anything like that. So if your buyer wants them to leave those items, then they need to be called out right here. This is where you would put the range oven, refrigerator if the buyer wants it, and then that smart equipment, whatever that might be. Then the excluding, so if you're going to exclude any of the items listed above, for instance, the curtains and the curtain rods, you could put them in here. Or if they have a swing set in the backyard and your buyer doesn't have any kids and they don't want it, then you could exclude it here, which would indicate they need to take it with them when they leave. The next thing on the list is the home heating fuel. So if you're dealing with property in rural areas, a lot of times they have propane gas. Actually, I looked at one yesterday that still has fuel oil, which I thought was crazy, but nevertheless, your buyer needs to make a decision at this point. Do they want that fuel that's left in that tank to be included in the sale, which means whatever fuel is left in the tank at the time of closing belongs to the buyer at the cost of the property? Or do they want it to will be purchased by the buyer at current market price measured within 5 days prior to closing? So in my mind, that's a tough one, because if it's a dead of winter and it's cold as the dickens, and you measure it 5 days prior to closing, a lot of fuel is going to be used up in the next 5 days. So is it fair to ask the buyer to pay for that? The other thing is, it does say that it's current market price. That's kind of a hard thing to determine, I think, because it's a matter of opinion. So the way I always do it myself, again, it's your business, you can do it your way, but I always check to be included in the sale. Makes things so much simpler. Or if there isn't any fuel that you need to worry about, then it's just not applicable. Then the price that you're going to pay for the property. So you're going to put it in here numerically, and then you're going to spell it out here in longhand. And the reason you do that is because your 2 might look like a 5 to me, or your 7 might look like a 1 to me. So to make sure that there's not a lot of confusion about what the number is, you write it out in longhand. If you're doing this in dot loop, and I'm sure when we switch over to DocuSign, it'll do the same thing. When you put the numeric number in here and you hit enter, it's automatically going to spell it out for you. Make sure you look at it, because the system might not read your 2 as a 5 or vice versa as well. The next item is the earnest money. So the buyer is going to submit an amount of money in US dollars as earnest money, which shall be applied to the purchase at closing, purchase price at closing. If not submitted with the purchase agreement, the earnest money shall be delivered to the escrow agent, which is the listing agent, within blank hours or days. Generally, when I'm writing an offer, I write in 3 business, so I type out business days after acceptance of the offer to purchase. So this is important for you to understand. Unless indicated otherwise in this agreement, the listing broker shall act as the escrow agent and shall, after acceptance of the agreement within 2 banking days of receipt of the earnest money, deposit the earnest money into the escrow account and hold it until the time of closing, the transaction or termination of this agreement. Earnest money shall be returned promptly to the buyer in the event this offer is not accepted. If the buyer fails for any reason to timely submit the earnest money in the contracted amount, the seller may terminate this agreement. This is very important for you to understand. So if you say 3 business days and it takes you 4 business days to deliver that earnest money, the seller has a right to cancel the contract, and you have no cause. So be sure that whatever you put in there in terms of how you're going to deliver the earnest money, that it is done so. And then I would want to get an acknowledgement from the agent on the other side that you did. Upon notification that the buyer or seller intends not to perform, and if the escrow agent is the broker, then the broker holding the earnest money may release the earnest money as provided in this agreement. It goes on to say, if there is no agreement, so if the buyer and the seller can't agree on who gets the earnest money, then the broker holding the earnest money can issue a 60-day letter, which is a letter sent out certified to all parties stating what they intend to do with the earnest money. Are they going to give it to the buyer or the seller? If either of the parties disagree with that, they have the right to file a claim. If they don't file the claim within 60 days, then the broker can release the funds to whomever they said they were going to release it to, and the broker is held harmless regardless of who he returns it to. You just need to understand that. So if the buyer disagrees that the seller should get the earnest money, they have 60 days to make a claim that they think that they should have it, and then they can take them to small claims court and resolve that issue. Legal remedies: if this offer is accepted and the buyer fails or refuses to close the transaction without legal cause, the earnest money shall be retained by the seller for damages seller has or will incur. Seller retains all rights to seek other legal and equitable remedies, which may include specific performance and additional monetary damages. All parties have the legal duty to use good faith and due diligence in completing the terms and conditions of this agreement. A material failure to perform any obligation under this agreement is a default which may subject the defaulting party to liability for damages and or other legal remedies, which, as stated above, may include specific performance and monetary damages in addition to loss of the earnest money. So if somebody is backing out of a contract for a reason not covered in the contract, they do or could be actually sued for non-performance. The method of payment: so are they going to pay cash? If they're going to pay cash, then there are some things that they need to meet here. They need to show proof of funds, either with the offer or within how many days after the acceptance of the offer. Will it be a new mortgage? If it is, then what kind of a mortgage will it be? Conventional, insured conventional, FHA, VA, or other? Other would be like USDA or rural housing. And then the mortgage will be, the loan will be for a percentage. So for instance, if it's FHA, 96.5% would go here because they're going to put 3.5% down. And then payable within however many years. Is it a 30-year note they're going to get, or is it a 15-year note, or maybe a 20? And then the original rate of interest is not to exceed. So whatever interest rate's been quoted to you by their lender, and I say to you because you need to verify this with the lender, is what percentage should go in there. And then not to exceed however many points. Today, most people are not paying points. In the old days, you always paid points on FHA loans. So usually that's just not applicable anymore. Then, whoops, I'm sorry, guys. The buyer shall pay all costs of obtaining financing except. So if your buyer needs prepaid or closing costs, this is where it's entered. So you would put in here, if they say they needed that, you talk to their lender again, and the lender said, hey, these guys need somebody to cover their prepaid and closing costs. And that amount's going to be about $4,500. So in this blank, you would write in seller to pay buyer's prepaid and closing costs in the amount of $4,500. I also include there that they are pre-approved with whomever they're pre-approved with, just to give the seller a level of confidence that they're dealing with a good buyer. You don't have to put that, but I generally put it in there. Are they going to assume a loan? Is it going to be a conditional sales contract? If it is, you need a financing addendum. Or are there some other form, some other method of payment? Are they going to give them 20 pigs, 2 cows, and $10? You know, then that's what would have to go there. All right, and then the time for obtaining financing. So within however many days, most of your buyers today are actually already pre-approved, but maybe they haven't actually filled out the loan application. So a lot of lenders will give you a pre-approval letter today after they've had a brief conversation with the client, thinking that the client's going to be fine, and they usually are, but they haven't filled out an actual application for a mortgage. So that's what goes here. I generally put in 3 days to give them an opportunity, especially if I'm writing an offer on a Friday, to give them an opportunity to fill out the loan application. Then the approval goes here. No more than however many days after acceptance of this agreement, they'll be allowed for obtaining the loan approval or mortgage assumption approval. If an approval is not obtained within the time specified above, this agreement may terminate unless an extension of time for this purpose is mutually agreed to in writing. So if you put 30 days there and the buyer can't get closed within 45 days, at the end of that 30 days, the seller has the right to cancel the contract. So here's how I do it. I generally put 45 days here, especially in today's market because things are just taking so darn long to close. And then in conjunction with the 45 days here, I make that match the closing date. So I count up the days until whatever date that is, 45 days later after acceptance. This is what I put here. That gives you that complete 45 days to closing to get that approval done. Well, back in the day, I guess 10 or 15 years ago, you could get a loan commitment letter. And a loan commitment letter basically said, yep, we're giving you the money, you've met every requirement, it's yours. So that's what people tend to think, whoops, sorry again, that's what people tend to think is what this is about. So that's why I always put 45 days, or in a good market where I know I can get financing quickly, I might put 30. Just remember, you got to live by that. You got to live and die by that. So closing date, here is, if they want to close, maybe they're going to close early. Instead of 45 days, they can get closed in 30, then you can put in here if you want to, 3 days after clear to close. So they get the clear to close. So you're saying to the seller at this point in time, I'm going to close either, you know, in this case, 45 days, or if I can get pre-approved and ready to close sooner than that, I agree that we're going to close 3 days after clear to close. You don't have to put anything in there, and the truth is I generally don't. You could put any kind of reason in there, but it just adds confusion to the whole process. So I generally leave it blank. Again, it's your business, your way. You can do it however you want to. So the fee, the settlement or closing fee incurred in conducting the settlement charged by the closing agent or company shall be paid by whom? So a closing fee is not a prepaid or closing cost. It's simply a fee that the title company or the closing agent charges both parties in order to do the closing. So that could be generally between $150 and $200 each. So the seller's charged the fee and the buyer is charged a fee. So who's going to pay for that? If you put shared equally, then I generally make a notation down in further comments that the seller's closing fee shall not exceed, and I'll generally put $200. The reason I do that is because when you present an offer, you want the seller to be able to get to their true net so they can decide whether or not this is a good offer or not. If you put shared equally, but you don't address what that shared equally could be, then it makes it very difficult then for the seller to determine what their true net is. Again, it's your business, your way. That's just how I do it. If I'm asking for prepaid and closing cost, I generally will say the buyer, and it's included in the allowance provided by the seller. Or you can simply say the seller pays it all. I don't know that a seller's ever done that in any deal I've ever done in the past, but if you say seller, then they're going to pay the buyer and the seller closing fee. Okay, the next thing down is contingency. This agreement is first, either is not contingent upon the closing of another transaction. So you have maybe a first-time home buyer, or you have somebody who's already sold their home and it's closed. It's already closed, so they don't have to worry about making a down payment on their next home based on the sale of their current home. So that's somebody who absolutely can go ahead and purchase without any contingency whatsoever regarding the funds. Okay, or it is contingent upon the closing of the pending transaction of the buyer's property. So then the address of that property and the scheduled closing date. So what did that purchase agreement say? When are they going to close? By the way, you need to coordinate that with whatever you say your closing date will be on this purchase agreement. You want them to be able, you want them to coincide enough that your buyer will be able to purchase once theirs closes, that they have time to do that. Or it is contingent upon the acceptance of a purchase agreement on the buyer's property. So you have a buyer, they have a property to sell, but that property has no offers on it yet. So that's when you would check this box. I don't know why that continues to do that. Again, I apologize. It is contingent upon the acceptance of a purchase agreement on the buyer property. So then there's an addendum to the purchase agreement for first right, which probably is what you're going to write in that case, or it's an addendum to purchase a limited purchase contingency right. There is an addendum for that, and we'll go over that at another time. Most always, you're going to be writing a first right contingency. if their property has no offer on it and must close in order to make the next purchase. The good funds, it just says that, you know, in the state of Indiana, you have to wire funds over $10,000 to the closing. Anything less than that, depending, by the way, upon the title company, because some title companies won't take anything unless it's a wire transfer, unless it's maybe under $500. So you want to check with your title company and find out what their policy is. But this says in Indiana, they're required to wire the funds to the closing if it's $10,000 or more. Followed by that is the wire fraud notification to the buyer, explaining to them how important it is to make sure that they're wiring the funds to the right location. That's something we'll talk about at another time. All right, so possession. When does the buyer expect to have possession of the property? So in today's market, it's usually at closing. But if you want to give the seller some additional days after closing to move out, then you check this box, and how many days are you going to give them? Those days begin the day after closing. So if you close on the 1st and you're going to give them 5 days, they have until the 6th, because the day of closing doesn't count as one of those days. And then you definitely want to put the time. So I can tell you many times an agent has left that blank. So what happens in that case, I had it happen to myself, a seller can say, well, you didn't put the time, so I'm going to give it to them at midnight on that day. I actually had a seller do that. My buyers had to go to their house, their own home, that they allowed the seller to stay in at midnight to get the keys. So you definitely want to make sure you notate the time in there. And then this first blank for money here, it says the seller shall pay to the buyer at closing, so many dollars per day if the seller does not deliver possession by the date and time required in the first sentence. So if you're giving them 5 days, but you're going to charge them rent for those 5 days, at the closing table, they are to write you a check for that. So if it's $100 a day, then they would write you a check for $500 if you're giving them 5 days. That's what that blank is for. If you're not going to charge them rent, you're just going to let them stay, then that could be a 0. But if they don't give you possession, this is the next block. If they don't give you possession when they say they will, then you can charge them a penalty, basically, for liquidated damages for the time that you don't have access to the property when you should have. So you can put an amount in here per day. I generally put $125. It gives a person a real strong incentive to get out. And the truth is, your buyer, $125 a day may not cover all their liquidated damages. They may have to put property in storage. They may have to rent a hotel room, and you can't hardly do that anymore for that kind of money. Nevertheless, that's what that's for. Okay, whoops. Maintenance of the property. This is important too. The seller shall maintain the property in its present condition until its possession is delivered to the buyer. So what that means is the day of closing, they're not clear if they get the property after closing. It's the day they turn the keys over. So they have to maintain the property in its current condition until that time. It goes on to say further, subject to repairs in response to any inspection. The buyer may inspect the property prior to closing to determine whether the seller has complied with the paragraph. Seller shall remove all debris and personal property not included in the sale. So remember, I was talking earlier, if they didn't want the swing set and they said it's excluded, then the seller needs to get that thing out of there by the day of closing or the day of possession. Okay, casualty or loss, risk of loss by damage or destruction to the property prior to the closing shall be borne by the seller, including any deductibles. So what this says is, if the property is damaged in some way before the seller gives possession to the buyer, and it's possession, not closing, to the buyer, then the seller is responsible for the cost of that repair. Utilities, seller shall pay for all municipal services and public utility charges through the day of possession, not the day of closing. Again, if they're giving them some time after closing to stay in the property, they have to leave the utilities on their own name until the day of possession. Okay, so next talk about surveys. These days, surveys are not done generally. If you represent a buyer who's going to buy a property, say in a rural area where it's a little difficult to determine where the actual property lines are, then they may want to do a survey. So survey location report, which is a survey where the corners are marked and not set, or a boundary survey, which is a survey where corner markers of the property are set prior to closing. They can do one of those two surveys, or they can waive it, which is what happens in most cases. In subdivisions, it's pretty easy to determine where the property lines are. But let's say they decide they want to do a survey. So now the next thing is who gets to pay for that? Is it the buyer's expense included in the allowance, if provided, or the seller's expense, or is it going to be shared equally? Once again, seller's expense or shared equally create a huge hurdle for the seller to get over because they may not know what that survey costs. An example, I represented a buyer. They were buying a 14-acre property. There was a barn on the property, and the seller made the statement they weren't sure if the barn was on their property or their neighbor's. Well, you knew that my buyers, you would know this because that's how it always works. The buyer definitely didn't want the property if the barn wasn't included. So a survey was done. We asked the seller to pay for it. They initially said no. We explained to the seller that the only one would benefit from this if in fact the barn was not on the property would be the seller, because then the buyer wasn't going to purchase the property. We made that clear. So we got the seller to pay for it. Next is flood area. I always check may. I never check may not. I did have an instance once here where an agent was told if they checked may, then they wouldn't accept the offer. There must have been a reason for it. And the reason was it was in a floodplain. So if you check may not and you find out it's in a floodplain, then you still have to move forward. You don't have a reason then to back out of the contract. So always check may. And then once again, building use limitations, the buyer may or may not terminate this agreement if the property is subject to a building or use limitation by reason of the location, which materially interfere with the buyer's intended use of the property. The buyer shall have how many what? How many days? How many hours? I generally put 3 to 5 days, 3 or 5, not 3-5, whichever number you think works best after acceptance of this agreement to satisfy this contingency. So we've had this happen also, where an agent checked may not terminate the agreement. And then they found out that the property they were buying to live in was actually a commercial property, and the city where it was located would not allow that to be used as a residence. So they had a huge problem because they had checked may not. So then they were required then to move forward with the purchase, even though they couldn't do what they wanted to with the property after they moved in. So I always check may, and I always give generally 5 days. Homeowners insurance. Completion of this transaction shall be contingent upon the buyer's ability to obtain a favorable written commitment for homeowners insurance within how many days? So homeowners insurance today is based on several things: the credit rating of the buyer, the experience the buyer may have had with homeowners insurance in the past, the experience that the current property owner has had with homeowners insurance on that property. All three of those factors affect the rate that is quoted by an insurance company for homeowners insurance. So the reason this is here is if there have been a lot of claims filed by the seller, if the buyer who maybe lives in a property now has filed a lot of claims while they live there, or if that buyer has very poor credit, then their cost for the homeowners insurance might be prohibitive. So they have however many days you put here. I generally put 10. They have within 10 days then from the acceptance of the offer to get a quote from the homeowners insurance company they intend to use. If they find that the cost of that insurance is too high for them, then they could get out of the contract. Environmental contaminants, advisory and release. So this says the buyer and seller acknowledge that the listing broker, the selling broker, and all licensees associated with the brokers are not experts and have no special training, knowledge, or experience with regard to the evaluation or existence of possible lead-based paint, radon, mold, or other biological contaminants, which might exist and affect the property. Environmental contaminants at harmful levels may cause property damage and serious illness, including but not limited to allergic and/or respiratory problems, particularly in persons with immune system problems, young children, or the elderly. Buyer is strongly advised to obtain inspections to fully determine the condition of the property and its environmental status. So what this says is, we, as the agent or anyone in our company, is not responsible for knowing whether or not there are those kind of contaminants on the property, and that we are held harmless if they find them later. This is on the buyer to do their own due diligence on this issue alone. Then it says the buyer and seller agree to consult with appropriate experts and accept all risk for environmental contaminants and release and hold harmless all brokers, their companies, etc. Now we go to inspections. The buyer has been made aware that independent inspections disclosing the condition of the property may be conducted and has been afforded the opportunity to require such inspections as a condition of this agreement. So now the buyer needs to make a decision. Are they going to do an inspection or are they not? My recommendation to you is to always encourage your buyer to do an inspection, even if it's a brand new property. I do encourage everyone to do home inspections. I did have a buyer once who was buying a brand new constructed property. They didn't want to do an inspection. I talked them into it, and they found out through no malignant or no malicious reason, they had failed to put the insulation in the attic. So they caught that before they moved in, which would have saved them some utility expenses. They may have been able to recover later, but the point is, it was a good idea they did the inspection. So they reserve the right to have an inspection, or they waive the right. I want to recommend strongly that you ask them to do a home inspection regardless of what they're buying. Vacant property would be the exception, sorry. Or the property is sold as is. So if you have a property that they acknowledge, that they tell you is being sold as is, then there is an as is addendum, which I hope we get to today, that we'll talk about, that covers. They can still do inspections, but they have to understand that the seller is not required to do any repairs as a result of those inspections. And then anything that was disclosed prior to the offer being made cannot be a reason for backing out of the purchase. Well, again, we'll get into that, I hope, before we're done here today. Inspection response. Initial inspection period, the buyer shall order all independent inspections after acceptance of the purchase agreement, and the buyer shall have how many days, beginning the day following the date of acceptance of the purchase agreement, to respond to the inspection reports in writing to the seller. So what this says is that the buyer, if you put 10 days in there, then the buyer can do their inspections as long as they make any repair request within the 10 days, then they're covered. If they do the inspection on the 10th day and then make an inspection request on day 11, they're not covered. The seller doesn't have to do the repairs, whatever they might be, and the buyer is required to move forward with the purchase. So just remember, whatever day you put here, you're held to get the request for any repairs to the seller within that time frame. These are, by the way, all calendar days unless specified otherwise in the agreement. So if you put 10 days and the 10th day falls on a Saturday, you don't get until Monday. You get 10 calendar days to make that inspection done. Then this talks about the scope of the inspection, all the things that they can inspect. If there's anything in addition to that, and they cover just about everything, then it needs to go here. You need to acknowledge that on the outset or at the outset. And then additional inspection. If initial inspection report reveals the presence of lead-based paint, radon, mold, or other biological contaminants, or any other condition that requires further examination or testing, then the buyer shall notify the seller in writing and have blank additional days. So you had 10 days in the beginning. So you got your inspection done on the 5th day, and your inspector said, look, I think there might be some foundational issues with the property. I'm not expert enough in myself to make that judgment. I think you need to call in a professional. That's when this additional days may come into play. So if you put 10 days for the inspection, and then you put 7 additional days, then for any additional inspection, not the initial, but any additional inspection, you actually have 17 days from the date of acceptance to get it done. So that doesn't mean on the 5th day that now you move down here and the 7-day clock starts. The 7-day clock doesn't start until the 10-day clock is completed. But that only applies to additional inspections that were required as a result of the initial inspection. Okay. If the buyer does not comply with any of the independent inspection response period or make a written objection to any problem revealed in a report within the applicable inspection response period, the property shall be deemed acceptable. Then the buyer must move forward, which is what we just said. A defect is identified in an inspection report reveals a defect with the property. The buyer must, one, provide the inspection report or the relevant parts of the report, or give the seller the opportunity to remedy the defects. So if a buyer does an inspection and they find something that is questionable, they have to give the seller, by agreeing to this purchase agreement, an opportunity to remedy the defect. Now that gets really very, very tricky. The buyer must also accept whatever that remedy is. So this becomes a real issue sometimes. You just need to make sure that your buyers understand the seller has the right to remedy, and they should give them that right. The seller's response to inspection defect: that the seller is unable or unwilling to remedy the defects to the buyer's reasonable satisfaction before closing or at a time otherwise agreed by the parties, by the way, in writing, then the buyer may terminate this agreement or waive such defects, and the transaction shall proceed forward. So it's telling you right there that if there are defects, they have to give the seller the right to remedy, but if they don't accept the remedy, they can still withdraw from the contract without penalty. Under Indiana law, it explains what a defect is. You need to make sure that your client, your buyer client, understands that. Me personally, when I get an accepted offer, I have an email that I send the client, what's next, and I actually copy and paste this defect defined in the email that I send them, in the section of the email regarding inspections, and make sure they understand what a defect really is. And then previously disclosed defect, the buyer agrees that any property defects previously disclosed by the seller or routine maintenance and minor repair items mentioned in any report shall not be the basis for termination of this agreement. So if the seller tells you going in that there's a foundational issue, then unless you say in the purchase agreement at the outset that this is going to be a condition of an inspection, then you can't use that as a reason to withdraw from the contract. Any disclosed defects on the front end, they would be found generally in the seller's disclosure. Inspection release: the buyer releases and holds harmless all brokers and their companies from any and all liability, including attorney's fees and costs arising out of or related to any inspection. So again, we get a waiver there where, again, we're not home inspectors, and they can't hold us liable for anything that a home inspector did or didn't do during the inspection process. Limited home warranty: the buyer acknowledges the availability of a limited home warranty program with a deductible paid by the buyer, which will or will not be provided at a cost not to exceed whatever that is, and a charge to the buyer or the seller, and then ordered by the buyer or the seller. So we use America's Preferred Home Warranty Company. It's a good company. You can look at their menu and see what price range your buyer is looking for in terms of a warranty. I usually always ask for one. You don't have to. You just have to check the proper boxes. One thing I will say to you is this: we do get a commission paid to us if we acquire a home warranty through the purchase agreement, if we meet certain conditions. If the seller is already offering a home warranty, they have obligated the seller, the listing agent has obligated the seller really to purchase that warranty. So if that warranty is being offered, I generally leave it then to the seller to choose and the seller to pay for, so that I don't cause that listing agent any problems down the road. Okay, next is the disclosures. The buyer either has or has not seen the seller's disclosure, or it's just not applicable, or the buyer has not seen the lead-based paint. Be sure and check those boxes correctly. If you say has not, then the buyer has an opportunity to review that before they move forward, even if the offer is accepted. So be sure and check the boxes correctly. Title approval: prior to closing, the buyer shall be furnished with. I generally always check the first box, a title insurance commitment for the most current and comprehensive auto owner's title insurance policy available. in the amount of the purchase price, or you can check an abstract. So an abstract is basically a written history of the property from the beginning, whenever the records were first started for that property. They're very difficult to come by these days. Most people don't do them. That's why I never ask for one. If you get a buyer that says, I'm not going to buy it without one, well, then you're going to have to ask for it. But abstracts are generally not provided these days. So owner's title insurance premium, and that portion of the title service fees incurred to prepare the owner's policy. So who's going to pay for that? Once again, it's a checkbox situation. So if I've asked for prepaid and closing costs, I generally say that the buyer, and it's included in the allowance. If I do anything other than that, once again, if you say the seller or shared equally, you've just put another hurdle in front of the seller. So then you need to address an amount of money that they would be held to no more than in the further conditions, in my opinion. Same thing on lender's title. Whether the buyer, it's included in the allowance, or the buyer is just going to pay for it outright. They're paying all their own prepaid and closing costs, or the seller is shared equally, or some other way. Then the next thing is the parties agree that the seller or the buyer will select a title insurance company to issue a title policy and will order the commitment. Okay, so in the state of Indiana, the buyer has the right to choose the title company. There are some sellers, particularly new construction people, who want you to use their title company. You're not required to, and they really shouldn't force you to. What my suggestion to you is this: since most buyers don't even know what the heck a title insurance title company is or what they do, I would find a title company that I trust and want to work with in the future, and I would ask my buyer's permission to use the title company that you prefer to use, or the lender that you always go with if they prefer to use, and I would go ahead and put it in here in the purchase agreement. So I always use a particular title company because I've always used them. They've always done a great job for me. So I always check that the buyer gets to, and they get to do it immediately, and then I put the title company's name in the purchase agreement. That says to the lender, this is who I want you to use as the title company. And it also says to the listing agent, well, this is the title company that'll be doing the closing for us. The reason I do that is because if I need a favor from that title company, I'm generally going to get it because they know I push as much business as I can their way. You should probably do the same thing. But as always, it's your business your way. All right, so taxes. In our market, it's almost always number 2 here. All taxes that have been accrued for any prior calendar year that remain unpaid shall be paid by the seller either to the county treasurer or the buyer in the form of a credit at closing. So in Indiana, we pay our taxes a year in arrears. So in May of this year, when you pay your tax bill, your property tax bill, you're really not paying it for 2020, you're paying it for May of 2019. So in every closing, there's going to be some property tax money that has to go one way or the other. So if you say I prorated up to the time of closing, then the seller is going to give a credit for the taxes that will come due that have not been paid yet for the time that they lived in the property. I think that's a fair way to do it. You can do other things if you choose to. You can say that the buyer will assume and pay all taxes on the property beginning with the taxes due on a certain date, whether it's either November or May in Indiana. If you do business with people a little bit further north, say Scottsburg, sometimes this becomes an issue where a seller says, I'll pay the spring installment, but I'm not paying anything after that. That's where this would come into play. And then for recent construction property, so if the property has been newly constructed, nobody's lived in it yet, but it's been on the market for say 6 months to a year, then you might want to put an amount here that would cover the cost of the actual taxes. Because what's going to be of record right now is the lot cost. So a lot cost might be, the taxes might be $20, $15, when in fact, when the tax bill comes due, or the next tax bill comes due, it could be for a lot of money because now the property has been completed and it's on there. So it just depends on when the assessor assesses the property. My understanding is, by the way, they can go back for 3 years to assess property taxes. So if the property's been on the market for, I would say 6 months or more, then you need to help the buyer determine what those possible taxes might be. And there's several ways to do that. You can look at similar properties in the same neighborhood, what their taxes are. You can call the treasurer's office or the assessor's office and ask them if they can help you with it, and they generally always do. So in that case, you definitely put an amount of money here. And by the way, builders, they understand that situation and generally don't complain too much unless you ask for way too much. Okay, so now we're down to the buyer may apply for current year exemptions or credits at or after closing. This just explains to them what those are. This says time is of the essence. Time period specified in this agreement and any subsequent addenda to the purchase agreement are calendar days and shall expire at 11:59 p.m. on the date stated unless the parties agree in writing to a different date and or time. So this includes any further amendments or addendum that you add to the purchase agreement. It's always calendar days unless you specify otherwise. The seller and buyer have the right to withdraw any offer or counteroffer prior to written acceptance and delivery of such offer or counteroffer. You know what? This can come into play if you have somebody who says, my sellers are going to look at all the offers, but they're not going to respond for 3 days. So you put in an offer, your buyer then sees a new property that hits the market before this seller is supposed to respond, and your buyer says, you know what? I don't think I want that one anymore. I want this one that just hit the market. So the first order of business then would be to withdraw that offer that you have on the other, that you have currently on the property, and then write a new offer on the new property. So the theory that this always works better for your client if you're the seller and you say, we're going to look at offers, but we're not going to answer offers until so many days out. It could cost you the sale of a good deal. One of the reasons I don't like doing that. Okay, homeowners association and condominium association documents for a mandatory membership association shall be delivered to the seller to the buyer by the seller within so many days. So if there are restrictions in the neighborhood, it's a subdivision of restrictions or it's condominium and they definitely have restrictions, then how many days are you going to give the seller to send those to the buyer for review? Usually most agents have those things already posted, but I generally put in there 3 days after acceptance of the agreement, even though I might actually be sending it to my buyer at the time that they accept the purchase agreement. And if the buyer does not make a written response to the documents within, and I give my guys about 3 days, the more days you give them, the more time the seller has to wonder if they're going to move forward. So you don't want to give them too many days. After receipt of the documents shall be deemed acceptable. So if they don't, in writing, respond to those documents and say, I'm not going to move forward because I found something in the restrictions that I didn't like and would keep me from buying the property within the number of days you just gave them, then they're going to move forward. Then I got to look back to any approval of the sale required by the association shall be obtained by the seller in writing within blank days after the buyer's approval of the documents. So if you're moving into a private community, a gated community maybe, and you have to be approved by the owner, the other property owners in there, that's where this would apply. I don't think you're going to see that too much in our market. Fees charged by the association or its management company for the purposes of verification of good standing and or transfer of ownership shall be shared equally by the buyer and the seller. Startup or one-time reserve fees, if any, shall be paid by the buyer. So a lot of condo associations turn their money over to a third party, and the third party generally charges you a fee for that information. This document says that the buyer and the seller are going to split the cost equally. I can tell you that it's usually not too bad, and generally the buyer ends up paying for it. The buyer acknowledges that in every neighborhood there are conditions which others may find objectionable. The buyer shall therefore be responsible to become fully acquainted with the neighborhood and other off-site conditions that could affect the property. So you're telling your buyer they're responsible for their due diligence. They're responsible for checking out the neighborhood and determining whether or not they think it's a good neighborhood. I did a virtual showing last night for a client, and they asked me, hey, Bob, is this a good neighborhood? I said, you know what? You should probably drive through the neighborhood and make that decision on your own. I don't know. I can't tell you. I don't live in the neighborhood. So we don't ever want to say to a buyer, oh, this is a bad neighborhood, or this is a wonderful neighborhood. You need to be careful how you say that because you might be putting yourself on the line there. What this says to the buyer is it's on you. It's up to you to do your own due diligence. Okay, next, attorney's fees. Any party to this agreement who is the prevailing party in any legal or equitable proceeding against the other party brought under or with relation to this agreement or transaction shall be additionally entitled to recover the court cost and reasonable attorney's fees from the non-prevailing party. So the buyer sues the seller. The seller is going to pay the buyer's attorney's fees if the buyer wins. If the buyer loses, then the buyer is going to pay the seller's attorney's fees and court costs. Just make sure that your client's aware of that. When a buyer says, well, I'm going to sue somebody, or a seller says, I'm going to sue somebody, they need to understand that if they lose, they're going to be paying for everybody. Okay, the additional provisions, unless otherwise provided, any prorations for rent, taxes, insurance, damage deposits, association dues or assessments, or any other items shall be computed as of the day immediately prior to the closing date. Pretty self-explanatory. Underground mining has occurred in Indiana, and buyers are advised of the availability of subsistence insurance. The broker is not responsible for providing or verifying this information. The Indiana State Police has created a registry of known meth-contaminated properties, which can be found at www. So on. Click on Clan Lab addresses. The broker is not responsible for providing or verifying this information. Now, we actually had this happen. We had an agent who sold a property. They were not aware that it was a prior meth lab and that it had not been cleaned. So when their buyer moved in, the neighbors told them that it was a meth lab. They then investigated and found out that it hadn't been cleaned, and they wanted to sue our agent because the agent didn't tell them. We're not required to know that. So, and this is basically what this says, that your client, the buyer, again, it's their responsibility to do the due diligence on things. Same thing here on sex offenders. They have a site they can go to. So if a client says, hey, is there a sex offender in the neighborhood? Your pat answer should be, you know what? You can go to this indianasheriffs.org site and see for yourself. I'm not sure, I don't know. Conveyance of the property shall be in general warranty deed or by a special warranty deed. If it's a sheriff's sale, it's going to be a special warranty deed. Generally, you're not going to have to deal with that. If it's determined that the seller is a foreign person subject to Foreign Investment in Real Property Tax Act, the seller will pay applicable tax obligation. And there are several other things here. You just need to take your time and read those. I don't want to take all your time today going through all these things. So we're going to skip on down to right here. The buyer discloses to the seller that the buyer holds an Indiana real estate license. So what that says is if you represent a licensed agent in their purchase of a property, and this does happen, then that client's license number goes here, not yours. So this says the buyer discloses to the seller that the buyer holds an Indiana real estate license. Now, if you are the buyer, then I would put my license number in there. So further conditions, one of the things that you might put in here is that if you've asked for the seller to pay their share of the title fee, seller shall pay no more than $200 for the title fee in this transaction. Buyer would be responsible for anything above that. That's something that you could put in there. If you want to make sure that they take that swing set with them, if you don't want it, then that's what should go there. So that's basically what the further conditions is for. This says to the buyer and seller acknowledge that they have been advised that prior to signing this document, they may seek the advice of an attorney for legal or tax consequences of this document and the transaction to which it relates. So you're saying to them, look, if you want to consult an attorney before you sign it, you can. I've actually had people do that. It doesn't happen very often, but you know what? It can happen. This is or is not a limited agency. So what is a limited agency? A limited agency is where you represent both the buyer and the seller in a transaction. That's one time. That's one way it's a limited agency. There's a special form for that. The limited agency form must be signed prior to you writing a purchase agreement. So that's the first form that you would present them with if you represent both parties. The other time that you're a limited agent is if you represent the buyer maybe or the seller, and another agent in our office, our Jeffersonville office, not any color agent, but in our Jeffersonville office also represents the other side. So 2 Keller agents within our office are on one transaction. You're also a limited agency in that situation. So in that situation, again, the buyer's limited agency agreement must be signed by all parties. So please be sure that you get that done, and please fill it in completely. I can't tell you the number of times I see them where the buyer's names or the seller's names are missing on the first page where they belong. You need that information on there. Okay, so when is this offer going to expire? Unless accepted in writing by the seller and delivered to the buyer by what time and on what day, this purchase agreement shall be null and void, and all parties shall be relieved of any and all liability or objections or obligations. So when will you give them to? So this is a tough one. In this market, properties are moving so fast, and you get into multiple offers so many times that you don't want to give the seller too much time, but you want to give them enough time. So that is just a judgment call on your part. I've gotten offers before on listings of mine where they gave me 2 hours, which in my opinion is just ridiculous. That's not nearly enough time. But it's so, as an example, if I'm writing an offer on what I think is going to be a hot property in the morning, say at 9 or 10 o'clock, I might give them till 9 or 10 o'clock that night. I might give them till 7 or 8 o'clock that day. If I'm writing an offer at 10 o'clock at night, I'm not going to make it expire at midnight that night. I might make it expire by noon the next day or 5 p.m. Whatever you think is a reasonable time for the seller to digest the offer, get to their bottom line, and make a good decision. That's what goes there. Okay, the buyer's signature goes here. Their printed name goes here. Please always put that so that the seller in responding can know the actual name of the person that is making the offer. So that's the end of the purchase agreement. Any questions on that, guys, at all?
No, I'm good. Thank you.
Oh, you're welcome. So now I'm going to go to, we talked about multiple offers. So let's say that in this case, you represent a seller or you're a buyer. You represent a buyer. And now you've been informed that you're in a multiple offer situation. This is what you should have received if you represent the buyer. This is what you should use if you represent the seller. It's simply the multiple offer notification. Obviously the date, the property address, the purchaser's name. So for everyone that writes an offer, you're going to do a separate form. So that the buyer's name, the selling firm, and the agent. And then down here, you're going to say, all offers must be in writing. No verbal offers will be considered or accepted. So in other words, they notify you it's a multiple offer situation. Your buyer says, well, let's raise it by $10,000. You can't just call, text, or email the listing agent, hey, we're gonna crank it up 10 grand. You have to provide something in writing that says that's what you're doing. All prospective buyers are receiving this notice, and all are being given until whatever date at whatever time to respond. So the seller can do several things, even if you do respond. Let's say you did add $10,000 to your first offer. So the seller can reject all the offers. The seller can accept one primary offer and accept any other offers as backups, or the seller can provide a counter offer to only one offer. So just because you have the highest bid on a property in a multiple offer situation doesn't mean you automatically get it. By the way, it also doesn't mean that just because you have the highest offer doesn't mean you're going to get it. It could go to somebody who wrote a smaller or lower offer. It depends on the other terms in that purchase agreement may affect whether or not the seller accepts your offer. So that's why I always say, put as few hurdles as possible in front of a seller so they can get to the true net. So a seller doesn't have to accept the best offer. They can accept the lowest offer if they choose to do so. So that you understand that. Any outstanding counteroffer by the seller is hereby withdrawn. So then the seller's going to sign it, and then the buyer's going to acknowledge that they received it. This is not the buyer's response to the multiple offer. This is the buyer acknowledging that they now know they're in a multiple offer situation. Any questions on that?
No, I don't have any.
Okay. So you wrote the purchase agreement. The seller got it and they countered your offer. Two things you need to know. First of all, they need to return that last page of the purchase agreement at a minimum, signed by the seller stating that they are going to counter. So you can't, if you just get this, the counter offer form, they haven't given you enough information. You need the last page of the purchase agreement signed and dated by the seller, returned with this counter offer page. So here's your counter offer. Which one is it? Is it the first one? So is it going to be a 1 or a 001, which is how I like to do it because you just have a little bit more to look at. This, again, it says for use by Indiana Association of Realtors. They all say that. So the date and time that the offer was, the counter offer is being written. The undersigned makes the following counter offer to the purchase agreement dated. So the date of the purchase agreement concerning a property commonly known as the property address, the township, the county, the city, they're not asking for the zip code for some reason. So here's where the seller's name goes. This is where the buyer's name goes. So if you don't print the buyer's name on the purchase agreement and they can't really read the signature, then it's pretty difficult then for the listing agent to fill out the buyer's name. And you definitely want it in there. And then what are the terms of the counter? So if they counter only the price, so they say, we agreed to the offer, except we want this much money instead of what you offered, then everything else in the purchase agreement applies if you accept the counter. Anything that they put in the counter applies. Anything that's not in the counter, you go back to the original purchase agreement, and that's what applies. So then you're going to get this if you're the buyer's agent. You're going to fill this out if you're the seller's agent. This counteroffer number, whatever this was up here, is void if not accepted in writing by the date and or the time and the date. Then the seller is going to sign it. They're going to check that they are the seller. You do this so for easy clarification later, if there are multiple counteroffers. Their name printed again, so that you can respond with the correct name if you do respond other than an acceptance. And then this is where the buyer signs the above counteroffer number, whatever that is. This is your response number, whatever that is. And it's either accepted, countered, or rejected, and the time. So if it's countered, then they're going to provide this and the counter. If it's rejected, you're done. If it's accepted, you're going to get your folks to sign this, and then you're going to return that. Again, you're going to check whether it's the buyer or the seller. That makes it very clear as to who's signing the document. Any questions on that?
No, I don't have any.
So here's what I would tell you. I've seen 4 and 5 counters before. So where they start countering this, and the next thing you know, they're countering that, and then they're countering something else. This becomes very, very difficult because at which time on what counter did we agree to this, whatever that might be. So here's just my rule of thumb. I'll accept a counter and I'll counter back. I won't go anything beyond that. I start all over. So after the second counter, I don't carry it any further. I just start all over. I write a new offer altogether. It just makes things a lot cleaner and easier to understand. Let's see what we got here. This is the as-is addendum. I said I hope we'd get to that, and here we are. So the as-is addendum. This addendum is dated the date of the purchase agreement. And on the property known as the property address, the city, the state, and the zip code. So what does it say? It's pretty clear. Number 1, except as modified by this addendum, all terms and conditions contained in the purchase agreement remain in full force and effect. So whatever's in the purchase agreement counts first, unless this as-is addendum counters it. In the event of any conflict between the terms and conditions of this addendum and the terms and conditions of the purchase agreement, the terms and conditions of this addendum shall prevail. So this counts first, and everything in the purchase agreement counts second if this addendum is used. I think I said that backwards at first. Seller and buyer acknowledge and agree that the property is being sold in its existing as is condition, and the seller shall not be responsible for repair, replacement, or modification of any deficiencies, malfunctions, or mechanical defects on the property, or to any improvements thereon, including but not limited to the material, workmanship, or mechanical components of the structures, foundations, roof, heating, plumbing, electrical, or sewage system, drainage or moisture conditions, air conditioning, hot water heater, appliances are damaged by the presence of pests, mold, or other organisms. Seller makes no representations or warranties to the buyer, either expressed or implied, as to the condition of the property, the zoning of the property, the suitability of the property for the buyer's intended use or purpose, or for any other use or purpose. However, the seller represents and warrants that the seller will maintain and repair the property so that the property will remain substantially the same, in the same condition on the closing date as it does the effective date of the purchase agreement. So what the seller is saying is, I'm not fixing anything, I'm not responsible for anything, but I'm not going to let it get any worse than it is today. And then the buyer shall order all independent inspections after acceptance of the purchase agreement. If the buyer's inspection uncovers any previously undisclosed defects. Remember I said on the purchase agreement, we would talk about this. So if they've disclosed those defects, then those, the buyer can't get out of the deal because of it. So if the buyer's inspection uncover any previously undisclosed defects in the property, the buyer shall have blank days beginning of the day following the date of acceptance of the purchase agreement to terminate the purchase agreement, in which case the earnest money shall be promptly returned to the buyer, and the seller shall have no obligation whatsoever to correct such defects to repair the property as a result of such inspections. In the alternative, the buyer may waive such defect and the transactions shall proceed toward closing. If the buyer does not terminate the agreement in writing or request additional time to respond within the specified time period, the property shall be deemed acceptable. Seller acknowledges and agrees that selling the property as is does not relieve the seller from applicable legal obligations to disclose any and all known material latent defects in the property and the improvements thereon, if any, to the buyer. So this says the seller can't say, if they know of defects, they can't say, well, I don't know. They have to tell you what those are. If they tell you what those are, you can't use those as a reason to withdraw your offer. The buyer acknowledges and agrees that the buyer has been advised to seek appropriate counsel regarding the risk of buying property as is. Neither the buyer nor the seller's respective brokers are qualified, licensed, or required to conduct due diligence or inspections with respects to the property or the surrounding area. The buyer expressly releases and holds harmless the brokers from and against any liability for any defects or conditions in the property and the improvements thereon, if any. So that says, once again, we're held harmless. They can't come after us if there's something wrong with the property that they either didn't catch after they purchased it, they found it. That's not on us, that's on them. It's always on the buyer to do their own due diligence, guys. Always on the buyer. Okay, any questions on that?
Nope. I'm
Okay,
good.
so go ahead.
No, I
Okay,
said I'm good.
Okay, you're good. All right. So
Yeah.
the last thing you're going to do, once you get through the inspections, you're going to do a final walkthrough. So here's the property address goes in place. It's pretty easy to see. Buyer's names spelled out so that you can clearly read them. The purchase agreement provides that the seller will deliver possession of the property to the buyer in the same condition as on the date the purchase agreement was executed. Normal wear and tear accepted and subject to any agreed repairs being completed before closing. Buyer should verify the condition of the property meets the terms of the purchase agreement. So this is a requirement here at Keller Williams, and I think honestly just about everywhere. So they either are going to do the walkthrough, the buyer walked through it and reviewed the property on whatever date, or the buyer chooses not to do the walkthrough. But if they do the walkthrough, the buyer releases and holds harmless all brokers and their companies from any and all liability, including attorney's fees and costs arising out of or related to any inspection result, repair, disclosed defect, or any deficiency affecting the property. We protect ourselves a lot through the whole process. The parties agree that this acknowledgement may be transmitted between them electronically or digitally, which means they can sign it electronically if they choose to. When your buyer signs this, they are accepting that property. So if they chose not to do the walkthrough, that's on them. It's not on you, but you should encourage them to do the walkthrough. If they say, well, will you go do it for me? I would not do it. You're asking the buyer to sign off on this. So don't do their work for them, do their work with them. So I've actually had buyers say, hey, Bob, I trust you. If you'll go do the walkthrough, I'll be fine. I won't do it. So I encourage you not to do it as well. You accept the liability, you don't need to. So the buyer walked through and reviewed the property, or the buyer chose not to. So that's the final walkthrough. That's the last document in terms of the purchase agreement that the buyer is going to have to sign until they get to closing, unless you've forgotten something. What about an addendum to the purchase agreement? So any addendum that you make, so an addendum is not a substantial change to the property. An amendment would be, where you're actually changing the terms of the purchase agreement. That's an amendment. An addendum is something that you're going to do regarding the property that doesn't specifically change the wording in the purchase agreement. So it could be any number of things. It could be that the buyer has decided to keep the swing set. I think that would probably fall under the addendum, although it would be amending the contract if it was in there. So that's the difference between an amendment and an addendum. And I think I've covered all the purchase docs. Is there anything anybody else wants to cover today while I'm here? Because I've still got just about 15 minutes that we can, if you want to.
Trying to think. I don't actually, I'm just the transaction coordinator for the Big Red team. So I'm
Okay,
not
well, that's
actually
okay.
an agent, but I am learning a few things. So that's good.
Okay, so this is being recorded, so you'll have access to it through our YouTube channel at some point in the future if you need it. The listing contract is there already. The COVID forms are there also.
Yeah.
So there are 2 YouTube videos for the COVID forms. One's for the purchase side, one's for the listing side. So if you go to our YouTube channel, you'll be able to see this again. It probably won't be up until tomorrow, but we're trying to record all of these so that you can refer to them whenever you want to. So go to our YouTube channel and you'll be good. In the meantime, thanks for being here, and we're out.
All right. Thank you.
Thanks,
All right.
Bob.
You're welcome. Take care.
You too.